Good afternoon, everyone. Sorry for the delay in our starting our webinar. I was attending court, so there was a bit of delay getting here. However, we're here now, so let's start with our topic. Today's topic is going to be about shareholder agreements, and I know everyone's excited to understand how they affect you and why they're necessary, and what your responsibilities and liabilities are, and how you can protect yourself. This is important. So let's get into it, and I will start introducing myself. So my name is 𝘄𝗵𝗶𝗃, and I am a lawyer who practices in business law, civil litigation, and criminal law. I have multiple years of experience working in court service division with various individuals as well as the public. I have been working in the legal industry for over 10 years, so I've gotten a good grasp of how legal procedures work, as well as the legal issues and concerns that individuals face on a daily basis. And I am excited to always assist clients, and I try my best to tailor every situation for the individual client and their legal needs. Please note that if you have any inquiries, I would suggest emailing me, or if you would like to schedule an appointment, you could always book an appointment with me at any time. And let's go into our topic today. So I'm going to introduce you to shareholder agreements. What is a shareholder and what are they? Why do they exist? So if you have a corporation, you would want to be a shareholder, especially if you own the corporation and you want to create multiple shares so that you can distribute these shares to individuals as well as yourself. You would want to make sure that you are creating shares that will allow you to get investments as well as be able to continue your business appropriately. These can be active or passive shareholders that you can actually create, as well as not automatically involved in the management process. So think about it. If you own the company or you created a company, you want to start off with creating shares that would allow you to benefit yourself, but you want to make sure that management decisions or decisions based on the company's direction should be something that you want to be able to make or provide an input into. So consider all these aspects when you're dealing with a shareholder agreement and how to prepare a shareholders agreement. What is a shareholders agreement? So this is usually something that most individuals are either unaware of or they tend to be able to be uncertain of. This is a contract between the shareholders. That means the company is owned by the shareholders and it's a specific amount of investment. It could be a dollar amount, it could be millions of dollars amount. But each share has a specific amount of investments that is created by the individuals who create the corporation. And so when we do the corporation, we want to have a shareholders agreement that will allow us to set up our rights, our obligations, and protect us from any kind of liability or negligence from the corporate decisions of directors or even any kind of issues of investment or creditors. So you want to be able to separate yourself from the corporation, and this is how shareholder agreements are set up in order to protect the individuals who own this corporation. It helps prevent disputes as well. It allows us to be able to have a dispute resolution situation within the shareholders agreement so that you protect yourself from disputes within the voting issues or any kind of financial decisions that are made in the corporation. So consider all of these aspects when you're actually creating a shareholder agreement. These shareholder agreements can become either very simplified depending on the kind of corporation you're creating. If your corporation is a small entrepreneur corporation where there's only one or two business owners, you want to be able to say, okay, I want the most simplified corporate shareholder agreement. And you might want to be able to implement specific discussions and issues within that shareholders agreement so that in the long run, if there's any disputes between the partnership or the shareholders who are just one or two or even family members, you want to be able to have that option to go to litigation or a dispute mediation or arbitration. These are all aspects of shareholders agreement that could be implemented within that shareholders agreement. So why do we need a shareholders agreement? Without a shareholders agreement, internal disagreements can lead to lawsuits or stalled business decisions. It creates structure and clarity for all parties. This is quite accurate. As I described earlier, the shareholders agreement implements how you deal with dispute resolutions. If you have two individuals, let's just say they are siblings of some sort, and they own a company, or not a company, but a corporation, and they purchase multiple different buildings where they supply specific type of products. At this point, the two siblings are running each different building, and the supplies are continually making funds for the corporation. However, without a shareholders agreement, how do you determine what percent of shares or what percent of shares actually provide funds as investments in the long term? Like when when the corporation starts making money, you end up getting that investment back to the shareholders. This is the reason why we have the shareholders agreement as well, because those investments need to be also included in how the the funds are redistributed within those shares to those individuals who will be making that funds. In this example that I'm providing, there are multitude of issues where the shareholders agreement might say one like there might not be a shareholders agreement because these two siblings decided we're family members, we won't have any disputes. But you're not the only ones involved. Remember, you have family members. If you pass away, if someone one of the siblings pass away, their wives or their husbands will be taking responsibility for the shares without a proper shareholder agreement. At the same time, if neither of the individuals pass away and there is no shareholders agreement and you don't know how the funds should be distributed because you have no shareholders agreement, now there becomes a dispute and you don't know how to resolve the dispute. You have to either one party might take advantage of the other party or the other one party might decide to go to a lawsuit. These are things that can be described within the shareholders agreement through various clauses that they actually put into the contract in order to assist the family members or shareholders to be able to make proper decisions. Then you're not liable when it comes to other issues that come up, like credit information, or you will have a shareholders agreement to protect you from the separation of the company and to allow you to get investments as well as be able to make those decisions that will increase the business and allow the business to succeed without constant legal issues and concerns coming in. So is important because it clarifies the expectations of each party and it reduces the legal disputes. It also protects minority shareholders and provides exit strategies. So, exit strategies are for shareholders. As I said, if someone passes away, you're not guaranteed that you can. If I was a corporation, I would want to have insurance or I would want to have clauses where one of the shareholders has a potential right to be able to purchase certain parts of the shares. These are all things that could be incorporated into your shareholder agreement in order to prevent any external individuals from being able to have decision-making power within your company. So consider all of these aspects when you're dealing with a shareholders agreement, because in order to be able to have a successful company, you want to be able to talk to your lawyer that can assist you with the shareholders agreement, and all parties who are starting or founding the organization should be able to have an input as to what type of shareholder agreement you want to be able to create, because there's multiple types of shareholder agreements. They don't actually only exist in one type. So this is one of the common type of shareholder agreement. This is a unanimous shareholder agreement that where all the individuals within that all the individuals shareholders within that agreement are permitted to have the right to vote on specific areas. But this is only one part. This can be only one part of the shareholder agreement, where there is a clause where you put in a unanimous shareholder agreement, or you can create a sorry, I can't say the word properly, unanimous shareholder agreement if you wanted to make sure that this is a family-owned company and everybody has an equal right, and you want to have everyone to be able to make that decision as a clear decision rather than have multiple individuals make different decisions. However, this is not the only type of shareholder agreement. You have to remember the shareholder agreement can change and does change depending on the type of corporation you're actually creating. Because remember, at one of my webinars, I did describe that there are multiple type of corporations. There's limited corporations, there's public corporations, and there's private corporations. Each of these corporations want to be able to make sure that when they're putting their corporation into the public or into services, let's say I'm a private corporation and I want to only conduct services for specific individuals, I don't need to have a complicated shareholders agreement, but I might want to make sure there's clauses in there regarding dispute resolution, regarding voting rights, regarding issues that might come up. So this is a unanimous shareholder agreement can occur in specific corporations where you want all the voting rights to be unanimous. However, there are multiple different type of shareholders agreement, as I indicated. Let's go to the next slide where we will discuss these multiple different type of like this startup aspect of the multiple shareholder agreement. This, when you're starting a corporation, it is important that you use at you, sorry, my apologies. I'm having a bit of a brain fart today. It's just exhausting sometimes just to wake up early and be able to do a lot of things. As well as as a business owner, you're probably doing all these things. So why would you want to have legal issues? So when you're starting up a corporation, the same like me, you don't want to be able to be in a position where you're like, oh, I don't know what I'm doing. I don't know how to deal with the situation. So you want to make sure you use the shareholders agreement at the startup stage. Set out the roles and responsibilities and share investment information for each share type, because there's multiple different types of shares as well, where you can be included in a specific shareholder agreement that allows you to have voting rights and non-voting right shares. And you can have shares that would allow you to have decision-making rights where you vote and you're able to vote on financial decisions and other decisions. And the non-voting shareholder rights is more like you are able to attend the meetings, you're able to see the issues, but you may not have the ability to vote on any of the decisions regarding, let's say, their corporation is deciding to acquire another property. You may not have that right if you have a non-voting share. So consider all of these aspects when you're starting up a shareholder agreement sorry, when you're incorporating and creating a shareholder agreement, because it's important to make sure that we have protected our company from the start, and these shares can change. So let's go to investment agreements. These are different types of agreements. So this is an agreement where it's not a shareholder agreement like the starting shareholder agreement that we just discussed in the previous slide. These investment agreements tend to have a specific relationship. They don't have any share rights, they have no voting rights, but the investment agreements may be incorporated in order to protect the investors so that they are the first to be paid. This is an essential part of how the investment agreement occurs. This actually allows the investments individuals to be able to get the funds without actually having issues in the long term. Now let's go to key clauses in shareholder agreements. This is important because these clauses are essential for most shareholder agreements as they allow you, but this is not the only clauses. To be honest, there's multiple types of clauses. Some of these clauses are essential because they actually tell you whether or not you're allowed to purchase shares from a person who's selling their shares, who has the first right to purchase it, who has the right, do I give do I want to sell the agreement? Do I want to sell the shares first to a specific individual and provide them with the right to be able to purchase it? Is that an appropriate measure that I can take? These are all aspects of the shareholder agreement that we, as shareholders or as individuals who are incorporating, need to make decisions on, because you don't want to have clauses in your shareholder agreement that don't implement these kind of decisions, especially if you're constantly growing your corporation. In the long run, your corporation may have issues because if you don't have certain, like, okay, how do we deal with disputes? Those kind of clauses. How do we deal with, like, who purchases the shares? These kind of clauses are important to the long run, especially if you are, how do I put it? If you are a shareholder who has a wife or a child or someone and you pass away, you may not be able to may not be able to get the shares to be purchased by the company. Rather, it might go to the partner or the individual who is left with those shares because they have it's it's almost like a will where the shares end up going back to the individual family as property. However, the drag along and tag along clauses, these kind of clauses allow you to purchase the shares prior to a person selling it. So these are all things that should be included within the shareholder agreement to protect you and your long um, your corporation's long life, that you want to make sure that the corporation's decisions are made for by specific individuals rather than every single individual who is able to purchase the shares. You want to make sure that specific shares stay within the specific individual corporation or specific, how do I put it? It's like, let me give you an example. If you, let's say the brothers that I indicated or the siblings that I indicated have a family that have siblings and have sisters and other individuals, if I purchase the shares from one of the siblings before the person who already owns the other part of the shares is able to do that, then These clauses will allow you to protect the sale of that from being sold to an external individual rather than being sold to the person who owns the other majority of the shares, if that makes sense. In order to simplify, basically, it just means if you don't include certain types of clause, your shares or the company's shares can be sold off to other individuals or individuals who have no interest in making sure the company succeeds or allows you to make a majority of decisions in the long term. So these are all aspects to consider when you're dealing with shareholders agreements and making sure that you implement specific clauses within the shareholder agreement, including restrictions that you want to make sure that are permitted within the legislation. So speak to a lawyer to discuss these options. This will all depend on your particular corporation and who are the investors and as well as who are the individuals purchasing those shares. So shareholder responsibilities. This is a good part of how shareholders are required to deal with the shares that they have. You're supposed to act in good faith towards the other shareholders, comply with the agreements and bylaws, and you have annual meetings which you are required to attend. If you're a voting shareholder, then you are required to attend these annual meetings, as well as you're supposed to be able to um, either bring a proxy. Proxy means you can actually ask someone else to attend the meeting on your behalf if you are a voting shareholder, which will allow other people to make decisions as long as you have provided them with the essential information from the corporation to be able to make that decision, or you've indicated what type of decision you want to be made. During annual meetings where the shareholders meet, there is voting sessions depending on what type of decisions are being made. You have to make sure that you are able to review the financial statements of the corporation as well as any concerns or any kind of long-term goals that the corporation is planning to incorporate into the corporation. These are all things that actually are discussed during shareholder meetings. However, shareholders require notice. If you don't provide adequate notice for the shareholders, they have the right to object to any decision that's made during that meeting. So consider all of these aspects when you're dealing with shareholder agreements, shareholder responsibilities, and you take on a shares that are voting shares. The non-voting shares usually don't have the right to make any decisions, but they have the right to attend these meetings or review any meeting notes and information, just as a shareholder who has the right to this information. So consider all of these aspects when you're purchasing shares or when you're actually incorporating a corporation with a shareholder agreement. What type of relationship do you want each shareholder to have? who is permitted to have who is permitted to buy voting shares that would allow them to make decisions during shareholder meetings, who should not have voting shares. These are all things that can be implemented into your shareholders agreement. So shareholders liability, this is a general concept because shareholders liability is very limited. As shareholders, you do not take responsibility for the company. You do not take responsibility for any decisions made by the company. Unless you become a shareholder, a director yourself, and you're acting as a director making those decisions, you incur director's liability for that purpose. But as shareholders, you will not incur that liability, and unless you committed a fraudulent act as being a shareholder, you're pretending to do something that's illegal, and indicating that these shares are yours and not your like, and you're actually trying to sell them without appropriate measures taken. These are all things that could create issues because you can be sued for these issues. Also, if you create personal liability by guaranteeing any kind of investments or any kind of leasing agreements, those create liabilities on yourself on a personal basis, not on the actual corporation itself. So those can actually create liability on you. So consider when you're doing agreements or when if you are a shareholder and you have incorporated and you're the only individual or you're one of multiple individuals who also assist in the operation of company as an officer or a director, these are considered important to look at the actual legal concepts and making sure that you're not taking personal responsibility and you're only signing on behalf of the corporation itself. So consider all of these aspects before you actually sign any agreement or provide any information to another individual so that your liability is limited because the corporation is taking the liability and not you. So, further shareholders' liability, as discussed, directors may assume obligations that are pretty broad in several circumstances, and they can also be shareholders. And sometimes directors are not always shareholders. But if you are a director and you do become a shareholder, if you are a shareholder and you do become a director, make sure that when you're making decisions, you're following the director's liability requirements and you're protecting yourself by getting insurance so that in any decisions that are made that causes liability towards you, including injuries and other issues, you have protection in some shape, form, or other. But your shareholders agreement would be separate from your director's responsibilities because you would still get the investment because, not the investment, the revenue that comes out of the surplus in which the shares actually are distributed, the funds are distributed through the shares because of those surpluses. You can actually be still getting those surpluses without having any issues with the director's responsibilities. An increased risk of liability only occurs when you are a director because you make more decisions. And be aware that sometimes when you make decisions, you have to always make sure that you're indicating that you're making these decisions as per your responsibility as a director to the corporation and not on your own behalf. Review agreements carefully. As I indicated repeatedly, review them. A lot of shareholders or directors do not review their agreements. They trust the agreement or the individual who prepares the agreement, and then they realize these agreements are going to backfire. And they're going to create a negative consequence for the corporation and loss for the corporation. So all of these aspects are important to consider when you're dealing with shareholders agreement. So consider them carefully, and if you are uncertain, speak to a lawyer who will review the agreement for you and determine the probable or possible issues and concerns that may come out of this incident. So make sure that you have actually used all external and internal review before you actually end up signing an agreement where you're taking responsibility for something you aren't aware of. So, best practices always use written shareholder agreements. Review it when your business changes and get legal advice before signing. These are all important. A lot of people sign agreements, and especially if you're a small entrepreneur or you're a small business owner, you tend to sign agreements without really reviewing the concepts. And sometimes, because there's a lot of legal jumbo mumbo on the agreements that most lawyers understand, or they actually will be able to review and be able to explain to you. People sign them because they're not sure, but sometimes they think the person that they're signing with is very trustworthy, or they believe they are trustworthy. Consider always getting legal advice, even if you're 100% sure this person is the best person in the world. Because reality is, at one point or another, your relationship can deteriorate and you can have a dispute. And I've seen it on multiple occasions where there has been a lot of conflict issues with directors, with shareholders, with family members who own a company together, and they don't even have shares or shareholder agreements, which causes a lot further disgruntled behavior, and one person may end up suing the other person, even though for the longest time they were fine and everything went well. So consider all of these issues, because in the long term, you don't want to go through the hassle of actually going to court to deal with these issues, because legal fees cost money. Consider the fact that lawyers' fees for civil litigation is expensive. It's not cheap, and if you don't have insurance to protect you from specific things, and sometimes even the insurance company will not cover you for specific issues. So even when you have insurance, make sure you understand what kind of issues can be covered by these um, insurance companies, because if you go into it blind, you also end up saying, hey, there's a fraudulent case against me, but the insurance company doesn't cover it because they don't cover fraud. So these are all things to be considered, and review your agreements repeatedly, at least twice, before you actually sign it. Do not just go blindly signing agreements expecting that the other person is doing everything in good faith. And key summaries and takeaways. Protect your investments with strong agreements. Make sure your contract has clauses, whether you want to purchase buy sell agreements, or whether you want to be able to purchase shares from another shareholder. If you want to be the one to have that right to purchase that share prior to anyone else purchasing that share, or if you want to sell to the shareholders without having to send it to other people. First, you have to include all of these agreements to protect the company. And if you're building a company that you want to succeed, and you want to be able to have decision making power within that company, these are all essential facts that you should consider, and these are things that should be included in your shareholders agreement. Also, the exit clause: if someone passes away, who has the right to purchase the shares on that occasion? If you Because the partner of that person has more than 100% right to be able to actually make decisions based on those shares now being transferred to her or him. And that can be an issue in the long run, because those people now have the right to make a decision where you thought, oh, I will have the right to make a decision. And the person that I was involved with is understanding and had the same business aspect. Now, the partner, there's no guarantee that they have the same business aspect or understanding, and they may make decisions in a different direction from which your vision was meant to go. So, as an entrepreneur, these are things to consider as essential part of your corporation and your shareholders agreement. Know your rights and limits. This is important. What are your voting rights? What are your rights to get sued? What are your rights to sue? If there is a minority shareholder who has only 10% voting rights, they have the right to sue only when there are specific conditions that are met. So these are all things that can be enclosed within your shareholders agreement. Shareholders agreements are very complex and very, very intricate. These are the agreements that are meant to be very specifically targeted based on the interests and visions of the individuals actually creating the corporation. And in the long run, if multiple shares are actually created, how would these shares be implemented or purchased? Or are they going to go on the stock market? Are they going to be able to create more revenue? What are these shares concepts that we want to include? So these are all aspects that we need to actually understand and make sure that we're making the appropriate decisions based on understanding the rights and knowledge that we have and our limits in that capacity as a shareholder. So let's take any questions. Are there any questions? I guess there's no questions at this time, but if you do ever have a question regarding any of the shareholders agreement or any other aspect of the business ownership, please do reach out by email. My email is at the bottom of the webinar here, and my phone number is also here. So if you, as well as look at the contact details. So thank you for attending this webinar, and I do appreciate that you took the time out of your busy schedule to listen in and hear this information. And looking forward to seeing you guys the following week. Thank you so much.